There it is. Hey, everybody. How are you doing? Um, don't have anybody in this live stream yet, but it will air as a regular video when I'm done. Unfortunately, the HQ level isn't good on this camera. It's just my webcam. But what we're going to do is we're going to run through Heller versus DC, which is the latest. It's the latest Supreme Court case involving the Second Amendment that deals with the issue of an individual right versus the militia right. In other words, is the Second Amendment contingent upon militia membership, and does the right to bear arms only deal with weapons that have a military use? Now, this question, military use. Hello, I've got a visitor. I don't know who you are. Let me see. Can I find out? Participants. Doesn't tell me anything. Oh well. So hi, welcome to my first official live stream. I did a test, and well, it was determined that it was advertiser unfriendly, of course. So I had to delete that test. Um, this video will, of course, re-air as a regular video after the live stream, and I just lost my only viewer. So what we're talking about is Heller versus DC, and the most modern interpretation by the Supreme Court of the Second Amendment. Now, there's a link you can click up in the chat that will allow you to read along with me. We're going to go through the case. And one of the reasons I wanted to do this is because nobody's covering it. Everybody still has it wrong on the Second Amendment. I mean, what it actually means. There's a lot of confusion. Now, to refresh myself, I thought maybe I could avoid actually reading the opinion again, and I looked at a few Heller versus DC analysis on YouTube. You know, speakers at universities talking about it, and it was like they weren't even covering the case. None of these people gave any cites from the case, discussed anything specific that the Supreme Court prevailing opinion by Justice Scalia talked about. Not really the heart of it. They concentrated on whether it was for military use or for um, private use. In other words, what exactly does the militia play in the Second Amendment? So this is the first case since I believe the case was Miller versus I'm not sure what state or whether it was the United States, um, where it was ruled that a sawed-off shotgun wasn't protected by the Second Amendment because it had no military application. Which I personally would happen to differ. If you're clearing a trench, a sawed-off shotgun comes in really handy, and it's really scary too. So the opinion that it doesn't have military use is incorrect, in my opinion. So I'm still waiting for more people to come because I don't really want to get into the actual reading of the case and the analysis until we actually have a couple of viewers. Um, Although this is going to run as another independent video, so I don't want to spend too long rambling on without getting into the meat of the subject without explaining. Um, so I'll just do this as an intro, this part, until I get at least one person listening. Oh, it's so funny. The joys of having a shadow banned YouTube channel. You know, can't get anybody to come in on a Second Amendment live chat. Can you believe that? Wow, huh? So let's talk about what the Supreme Court in general ruled in Heller versus DC. Hey, the right to bear arms is an individual right. It's not contingent upon militia membership. It has nothing directly to do with the militia. In fact, the Second Amendment is, in a way, a byproduct of the fact that there is a militia. Okay, um, basically, this Heller versus DC pretty much made the point that the Second Amendment is to so that the individual can protect himself from the militia. Oh, now, yeah, I don't know. Say you're a lefty and some right wing militia takes over your town and goes through City Hall and the Democratic offices, finds out all the registered Democrats, takes them into some compound and kills them all. And that's what they're doing. Uh, According to a lot of interpretations by gun nuts who say, "Oh, we're the militia. We have a gun right." According to them, you might, you're not in a militia, so you wouldn't have a gun right, and you couldn't defend yourselves from this rogue militia, quote unquote, from Heller versus DC. You wouldn't be able to protect yourself from a rogue militia if you didn't have an individual right to bear arms. So, in Heller versus DC, it becomes really clear that also that when you're talking about a militia, you're talking about something that the government can call up. So we're talking about government militias for the most part. That doesn't mean they can't go rogue, okay, or become politicized. And they talk about that, and they talk about standing armies. The whole idea behind having all able bodied men being part of the militia is that it precludes the need for a standing army because all you have to do is call up the readily trained militia that's already organized into battalions, blah, 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 blah. So, anyway, with that, let's actually get into the case. Supreme Court of the United States, District of Columbia, et al., petitioners versus Dick Anthony Heller. And this is an appeal to the Supreme Court by the state, D.C. In other words, the appellate court, the circuit appellate court, directed the lower court to issue a firearms license to Heller. Then the state, D.C., appealed that to the Supreme Court. So the District of Columbia is the petitioner, and the Heller is the respondent. Okay, so says here, I'm going to scan through the introduction. District of Columbia generally prohibits the possession of handguns. This is written by Justice Scalia, by the way. It's the prevailing opinion. We may go through the dissenting opinion also, depending on how I feel at the end of this. Okay, it's a crime to carry an unregistered firearm, and the registration of handguns is prohibited. See DC code, and it has a bunch of numbers. There's a link there if you want to read along. Wholly apart from that prohibition, no person may carry a handgun without a license, but the chief of police may issue licenses for 1-year periods. District of Columbia law also requires the residents to keep their lawfully owned firearms, such as registered long guns, unloaded and disassembled or bound by a trigger lock or similar device unless they are located in a place of business or are being used for lawful recreational activities. Respondent Dick Heller is a D.C. Special Police officer authorized to carry a handgun while on duty at the Federal Judicial Center. So, Heller is a policeman, and they still won't give him a permit. He applied for a registration certificate for a handgun that he wished to keep at home, but the district refused. He thereafter filed a lawsuit in the federal district court for the District of Columbia, seeking, on Second Amendment grounds, to enjoin the city from enforcing the bar on the registration of handguns. The licensing requirement, insofar as it prohibits the carry of a firearm in the home without a license, and the trigger lock requirement, insofar as prohibits the use of functional firearms within the home. The district court dismissed respondent's complaint. See Parker v. District of Columbia. The Court of Appeals for the District of Columbia Circuit, construing his complaint as seeking the right to render a firearm operable and carried about his home in that condition only when necessary for self-defense, reversed, see Parker versus District of Columbia. It held that the Second Amendment protects an individual right to possess firearms and that the city's total ban on handguns, as well as its requirement that firearms in the home be kept non-functional, even when necessary for self-defense, violated that right. The Court of Appeals directed the district court to enter summary judgment for the respondent. All right. We granted appeal, certiorari, it says. And we first turn to the meaning of the Second Amendment. The Second Amendment provides, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In interpreting this text, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary, as distinguished from technical meaning. See also Gibbons versus Ogden. So, the Constitution isn't written in legalese. It's written to be interpreted with the common usage of the words at the time the Constitution was written. Its words and phrases were used in the normal and ordinary as distinguished from technical meaning. Normal meaning may, of course, include an idiomatic meaning, but it excludes secret or technical meanings that would not have been known to ordinary citizens in the founding generation. The two sides in this case have set out very different interpretations of the amendment. Petitioners and today's dissenting justices believe that it protects only the right to possess and carry a firearm in connection with militia service. See the brief for petitioners. Respondent argues that it protects an individual right to possess a firearm unconnected with service in the militia and to use that arm for traditionally lawful purpose such as self-defense within the home. The Second Amendment is naturally divided into two parts, its prefatory clause and its operative clause. The former does not limit the latter grammatically, but rather announces a purpose. The amendment could be rephrased, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. See some treatise here. You can look it up if you want to go to the link. Although this structure of the Second Amendment is unique in our Constitution, other legal documents of the founding era, particularly individual rights provisions of the state constitutions, commonly included a prefatory statement of purpose. See generally Volokh, the commonplace Second Amendment. Logic demands that there be a link between the stated purpose and the command. Let me take a break for a minute or so before I continue on this one. This is where it talks about the grammar logic demands. So, right now, he's talking about the question of whether the Second Amendment is contingent upon the militia. In other words, do you have a Second Amendment because you are a member of the militia? And the militia defined back then was all able bodied men of fighting age. Okay. So that means if you weren't able bodied and weren't of fighting age, according to the militia argument, then you don't have a First Amendment right. Now, that's according to the militia argument. Now, being 61 and disabled and not able bodied, not part of a militia, I don't agree with the fact that, with the opinion that, you know, the Second Amendment is related to militia service. Now, it is related to militias, but not in that way, which the Supreme Court will get into as we move on. Oh, get these paper towels out of the way and mess up my background, which is kind of already messed up. So, I wonder where everybody is. Zero viewers. I guess you could call this a failed live stream. I was hoping to get some input and questions because questions help direct the discussion. And I'm left with just reading it and pausing now and then to explain what I just read. So I think I'm going to give this a few more minutes and moving into the grammar of the Second Amendment, which is what they're going to talk about next, the separation by the comma between the militia and the people. It indicates a difference. And we're going to work on that on the next video. But I'm going to go ahead and end the stream because no one's here. And this will be converted into a regular video. And, maybe if you want to talk about, if you want to hear about the comma and the grammar, watch for my next live stream. This is Dave from Verified News, checking out.